No, I filed a response to the motion.
Okay, give me just a second. Hold on. Anna, I just got, do I hit yes or no? I got a script error. Just exit out. Here, I'll print out a copy for,
Only after I e-file a copy, I email it to the court, copy court owners, we get a chance to use it.
it's okay. We'll take a look at it real quick. So, sir, are you Calvin Hawkins? And this is 24 DCCR 1160. Mr. Hawkins is charged with unlawful possession of a firearm by a felon. Looks like the bond is currently set at $100,000.
All right, pause right here. A $100,000 bond for unlawful possession of firearm by a felon is already serious. But what really hurts a defense is what comes next. When a defendant misses a court date, judges see that as a flight risk. And once that happens, bond almost never goes down. It usually goes up.
There was a court date, March 31st, that Mr. Hawkins did not appear, and so there was a bond forfeiture, and the bond was raised to $100,000 at that time based on that. And then Mr. Macon looks like was hired, filed motions and letter of representation in October. So here is Mr. Macon, the state's. I don't know why it printed like this. Oh my gosh. No, I mean I printed 2 copies and it printed like 1122. It hasn't done that in the past ever. When I've never seen it before. It never has done it.
Thank you.
Okay, so the state filed a reply to Mr. Macon's motion asking for a bond to be reduced. Take a look. Go ahead. Yeah.
Page 2, it's referred to the and also on page 2, the very bottom refers to jail write-ups, and that's essentially the state's what the state would ask the court to take into consideration if you are so inclined to reduce the defendant's bond. Criminal.
This is the moment where things quietly fall apart for the defense. For prior felony convictions, burglary, theft, cocaine possession, and felony marijuana, plus jail write-ups, judges don't just hear mistakes. They hear pattern. And patterns matter more than promises in bond hearings.
Including 4 previous felony convictions, 1 for burglary, a felony theft, possession of cocaine, and a felony marijuana. And he's been also recommended by jail staff for possessing contraband in jail and failing to follow these restricting rules of staff.
All right, thank you, Mr. Coleman. And I am getting a copies of any jail incident reports.
I've attached a couple of those reports to my motion.
Oh, okay, I see those. Would you check and see if there's anything since December 3rd, please?
Yeah.
Okay. So the prior, all of those offenses, the burglary, theft, possession of cocaine, and felony possession of marijuana, all of those are felony offenses and convictions, correct?
That's my understanding.
Mr. Macon, you may proceed.
Yes, Your Honor. First off, Mr. Hawkins, you're unable to make the 100,000.
Hold on just a second. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. I'm sorry, Mr. Wayne.
Would you state your name, please? And you've been unable to make the $100,000 bond, correct? Okay, do you have family and friends that were a reasonable bond was set that you could make? Yes. Okay, now you understand you're from Florida, so if you make a bond, you have to state Jefferson County.
Listen closely to this part. GPS monitoring drug patches, strict location rules. These are the court saying, even if I let you out, I don't trust you. Question for you. If you were the judge, would these conditions be enough, or is the risk still too high? This sounds like a big reveal, but legally it's shaky. A witness changing their story after the arrest doesn't erase probable cause. Judges focus on what officers knew at the time, not what someone says later when the stakes are high.
Okay. So for the record, I have reviewed the probable cause affidavit. I also did receive notification, and if anyone has questions for the bondsman's representative is here today, and her company had to hire a bounty hunter to locate and get Mr. Hawkins after that bond forfeiture. So obviously, to me, that would indicate that he was not keeping up with his bondsman, and otherwise he would have. If you bond out, you've got a bondsman. You check in once a week. You would know you have a court date. If you miss a court date, you would know there's a warrant. So there's that issue as well. Mr. Coleman, what's the state's position?
So the only thing I had, Judge, is that he's subject to a habitual offender enhancement, making it 25.
This single sentence changes everything. Habitual offender enhancement means a convicted, sentencing exposure explodes. Judges absolutely consider that when deciding bond, because higher potential prison time equals higher incentive to run.
Okay. At this time, based on the nature of the offense itself, the unlawful possession of a firearm by a felon, the probable cause affidavit, and the information that was in that, there were 3 vape pens found as well. I know obviously none of this is proven, but it is important to know. Everybody had different opinions, or the 2 of them, about where the gun was, whose it was. They both said it wasn't theirs. And the fact that he missed court and had a bondsman, and that bondsman had to get a bounty hunter to get him back here. And the fact that he's from Florida, was apparently working supposedly in Louisiana and driving through here to sightsee in Houston when he was arrested, gives me concern about all of that. And so at this time, I'm going to deny the motion to reduce the bond. The bond will remain at 100.
And there it is. Bond denied. This wasn't about just a gun. It was about Miss Court, the bounty hunter, conflicting stories, past felonies, and credibility. Judges don't rule on sympathy. They rule on risk. Do you agree with this decision? Let me know below.
100,000. I'll reset the case for an announcement, and we'll get it moving in whatever direction it needs to at that time. All right?
I wasn't arrested at all.
When? But you had a bondsman, so at some point.
After I found out I had a warrant.
Right.
I was keeping up with my bondsman. I texted her and said I was trying to.
Here's the thing. She's here, so be careful what you say. I've already made my ruling. You can go back with the bailiff.